Hi, welcome back to Space Thoughts. I mentioned in my video on April 22nd on the Vancouver guidelines, I mentioned at the end that the UAE had dropped its domestic space law. In other words, they made it public, and this is the English version of the law. I actually have a copy of it here that I'm going to go through a little bit in this video. It's not going to be an expansive analysis of it, just because I don't want to sit here for an hour or two discussing the law and boring everybody. But I'm going to hit some of what I think are the highlights. And for those of you who've subscribed to my briefing letter, I'm probably going to cover this a little more detailed in my next quarterly issue, which will be coming out at the end of June, either the 27th or the 28th. Now, I want you to understand what the copy of the law that I have is made public. I was assured that it's okay to share this, so I'm not sharing something that isn't supposed to be in the public eye. And I'm going to remind people that this is the English version, and that the English translation from Arabic isn't exactly one-to-one. So there's going to be some, there's been a little bit of give on how the meanings of the words and the translation. So I'm just going to switch over this and do a side-by-side on this. And this is a pretty interesting law. I've had a chance to really gloss through it and look at some of the things, and I'm going to focus on what I think are some of the important highlights. And number one is basically with the definitions, and that's in Article 1 of the law. And basically it goes through definitions for purposes of the law. And some of the things that I think are important. Let's see. For example, orbital spaceflight, a spaceflight with the intention of completing an orbit around the Earth. Suborbital spaceflight, a spaceflight with the intent to enter the defined area without the intention of completing an orbit around the Earth. And we're going to go into defined area into a moment. Now, I think this is significant because the UAE's been in talks with, I believe, Virgin Galactic to actually sponsor space tourism flights, and all those flights are going to be suborbital. So this will basically define those flights within the law in terms of how they authorize them. So in other words, this won't necessarily be a flight into space, but it'll be what we call a suborbital flight, depending on the law. Interestingly, they also address high altitude activities that are above the scope of air traffic control and lower than the defined area. And again, we're going to get to that definition of defined area in a moment, because I think it's very interesting how they did this. This is interesting because they're taking the same approach as I believe New Zealand did. They included what we call high altitude activities in their bill as well, in their bill as well, and that basically covers high altitude balloon flights and such. Those things that don't quite reach the cusp of what they would consider a suborbital flight or into space. Space data from space activities, whether it's remote sensing data or navigation data using satellites or other means. Data is money nowadays. I mean, basically, it's basically the big revenue generator right now, and from commercial imaging satellites, remote sensing as we call them. And this is so they have specifically defined this in part of their law, and to make it kind of all-encompassing. Going to the next page, meteorite, a natural mass or metal stone that is not man-made, reaching the Earth from outer space without human intervention. And it's interesting, this is interesting because a little bit down here you see the definition of space resources: any non-living resource present in outer space, including minerals and water. Now, I'm going to cover this in a little bit, but the UAE does have a domestic space resource provision in their law that allows private entities to actually acquire space resources. Interesting what this is doing, what the law does, it differentiates between a meteorite that reaches the surface of the Earth without human intervention and a space resource that is basically something that is actually acquired through human intervention. So I think that's pretty interesting they make that delineation in that. Very interestingly, they basically they define space debris, a space object or part thereof that is no longer has a role or any purpose, including its parts or components and the resulting materials, wastes, or fragments, whether in outer space, including the Earth's orbit, or within the Earth's atmosphere. I think this is very interesting, given how important the issue of space debris is right now, and the fact that the UAE decided to really encompass an actual definition of how they define space debris is important. And this is interesting because I've been kind of wrestling with the idea of space debris, and I actually wrote an article several years ago that actually had a layered approach or what I call the totality of the circumstances test to actually define what space debris is. Here, for the case of the UAE law, they decided this is how they're going to define space debris in terms of their law and their legal structure. Now, this won't necessarily be adopted as an international standard, but what I'm saying is for purposes of their law and their activities, that's what they're going to define space debris as. And like I said, I think this is very interesting. Space nuclear power sources, devices used in space activities to generate energy and using nuclear materials, radioisotopes, or a nuclear reactor. Again, nuclear energy has been a big issue nowadays. I think the U.S. Actually introduced a protocol for nuclear power in space. I believe it was last year sometime. And the fact that UAE is actually including a definition, or at least giving it consideration in their law, is significant. Person, natural legal person, operator, a person who carries out space activities, space support flight activities, high altitude activities, space data management and dissemination activities, or any other relevant activities subject to this law. In other words, the term operator encompasses a broad range of activities, whether it be in outer space itself, whether it's remote sensing, whatever. Basically, this is a very all-encompassing definition of what operator will be for the purposes of this law. It's interesting they also come up with dual-use commodities, goods that have a dual use for civil or commercial or military purposes, or used in manufacturing or developing of weapons of mass destruction, pursuant to Federal Law Number 13 of 2007. And again, at the beginning of this, they list other federal laws that this refers to. I think this is very interesting because dual use is a big issue when defining things like what's a space weapon. Is a space object being used as a space weapon or not? The law actually defines or recognizes the idea that space objects or products produced in space can have a dual use, whether civil, commercial, or military. Excuse me. Outer space. And this is very interesting. They take first of all, they define outer space as the area above the Earth's atmosphere, and I think this falls in line with. Let me go back here a little bit. I believe. There we go. I missed it up here. This kind of coincides with the area of defined area, and defined area is an area 80 kilometers or more above the average level of the sea level. So my first thoughts when I saw this was, oh, they're taking what we call a spatial approach to delimiting between where the atmosphere stops and outer space begins. However, when I looked at the definition of outer space, I'm saying, oh, wait a minute, they're defining outer space as the area above the atmosphere, but here they are, for the purposes of the law, they are basically demarcating an area 80 kilometers or more above the average level of sea level. So what I'm looking at here is basically an understanding that what they're trying to do is basically set some sort of hard line of where this law actually takes effect. Because if you notice down here in high altitude activities, it notes that these are activities that are above the scope of air traffic control and lower than defined area, like high altitude balloons and those types of activities. So my understanding is they are not trying to actually create a delimitation where the atmosphere ends and outer space begins, which is kind of a big international issue and has been ever since the opening of the space age. But I think what they're trying to do is they're saying, look, this is the point where this law takes effect, and below that, this law doesn't take effect. So, and this is kind of the issue with the whole delimitation argument, is that if you set a hard point where outer space begins and the atmosphere ends, a different set of laws takes over. And what they're saying here in this defined area, 80 kilometers or more, they are basically saying this is where this law takes effect. And you'll notice in here throughout the definitions, it will refer to the defined area, and the defined area will be referenced throughout the law in terms of other areas. Let's see what we got here. Again, defines launch vehicle, defines person, defines operator. Authorization, a document granted by the agency to a person authorizing him to carry out the activities listed therein, including licenses, approvals, permits in accordance with the provisions of this law. Again, this gets back to Article 6 of the Outer Space Treaty, the authorization and continuing supervision of private non-governmental space actors. So this is basically saying that a definition of, basically what an authorized operator is. Space sector, the sector that includes all activities, projects, and programs related to outer space. And again, this is kind of where I'm having a little bit of a challenge understanding. They have the defined area. I understand that, where they want to basically set this is the area where our law will take effect. But they define the area above the Earth's atmosphere as outer space, and the space sector as a sector that includes all activities, projects, and programs related to outer space. So really, I don't think the defined area is setting up an actual domestic delimitation of where the atmosphere ends and outer space begins. But I think, like I said, it's just a matter of they're trying to say, look, we need a point where we're going to say these laws are going to take effect and this where it is, instead of making a statement that basically this is what we believe the atmosphere ends and outer space begins. So I think they're kind of just trying to dance around that a little bit without causing controversy, because like I said, it is a controversial issue. It comes up every year at the UN, and there's a lot of discussion about it. Nations like the U.S. just have basically been consistent in saying we just don't need a definition of outer space. But other nations think it's important, and actually some states in their domestic space laws have actually come out and say we believe this is where the atmosphere ends and outer space begins. But then they pull back a little bit and saying we're not saying this should be the international standard. This is just our standard. So I think the way they treat this is very interesting, and I think they thought it out a little bit in terms of potential geopolitical ramifications that it could have. Convention on Registration of Space Objects launched in outer space. They're just mentioning that they ratified it in one of their federal laws. They actually enacted it in one of their federal laws. So it's basically what I say is that convention, that treaty, the liability, the registration convention has actually become part of their domestic law. And just like the U.S., and just like in anything, in the U.S. treaty, a ratified treaty has the force of federal law. And this is what we're seeing right here. And again, we go into Article 2, Objectives of the Law. And basically, this is all laid out similarly to how other domestic space laws have been laid out. Although it's I will say it's a lot more thorough, and they've taken the experience of other states that have enacted domestic space laws, and in my opinion, they've built on them. What I want to do is I want to jump ahead to the space resources provision, space resource exploration or extraction activities. And that's in Article 18, extraction, exploitation, utilization of space resources. Now I mentioned earlier that they differentiated between a meteorite, which is something that falls to Earth, and a space resource. And basically here in Article 18, one of the things that they wanted to do is they wanted to have a domestic space resource law. In other words, to grant a right to actually perform space resource activities for private citizens under its jurisdiction in outer space. And this makes the UAE unique in the Middle East region because they are the only ones that have adopted something like this. And this is something I've been talking about for several years while this law has been coming into being, because the rumor was that they were going to adopt a space resource provision similar to what the U.S. and Luxembourg have done. And before I go delve into this a little bit, a lot of that has to do with, I think, positioning themselves economically. Luxembourg, for example, I believe is the primary reason for them adopting a domestic space law similar to on space resources similar to the U.S. is because they wanted to become basically an economic hub for clearing space resources. In other words, not necessarily for physically receiving space resources, but for transferring the economic value of space resources. So they kind of become an economic hub for that in the EU. Now, right here, I believe what the UAE is doing by providing for space resource rights for private individuals, they're becoming an economic hub for space resources in the Middle East, because most of their neighbors around them have signed on to or ratified or otherwise acceded to the Moon Agreement. And basically from that executive order we saw earlier in the month, the U.S. is basically positing the position the Moon Agreement is dead. We're not going to even recognize it as custom. So basically, by jumping on here and actually doing this, they're kind of joining in its essence, taking the approach that the Moon Agreement isn't the approach we want to take. We want to take the approach of space resources, as opposed to their neighbors who are basically have signed on to the idea of the Moon Agreement. Now, what's to say they'll continue on with the Moon Agreement remains to be seen. But for now, the UAE is kind of leading in the Middle East on this area of adopting the idea of space resources, and I think that's going to be important for the U.S. effort to actually create some international consensus, because now that UAE has a law, they're probably going to be more receptive to working with maybe the U.S. in actually developing norms and standards for space resource activity. Okay, Article 18, extraction, exploitation, and utilization of space resources. Subject to provisions of Article 14, terms and conditions relating to authorization for extraction, exploitation, and utilization of space resources, including their ownership, purchase, sale, trade, transportation, storage, and any space activities aimed at providing logistical services in this regard shall be determined by decision issued by the Council of Ministers or whomever delegates it. So in other words, this is laying at the foundation. We're going to permit this type of activity. We're going to allow space resources to be acquired, owned, purchased, sold, trade, or transported or stored under the guise of their Article 6 authority. And basically whoever is, whatever ministry is in charge of actually authorizing those activities. And basically this subsection goes into authorization, and but basically this lays out the authorization for space resources. Now this is just the foundation for further regulation of exactly what the process is for that. But it is going to have to be an approval process, and looks like it's going to be a decision by a board of directors, and not just one person or entity in that sense. So that's extremely important, given all the, in my opinion, given all the activity and controversy over space resources, especially with the U.S. executive order back on April 6th. That makes this right here kind of lends support to the idea that this is going to be the way we move forward, and further reinforces that the Moon Agreement really doesn't have any more pull. It's essentially dead, and it's really not going. Its ideas and approach isn't going to prevail for this type of activity. Another interesting one I want to go for is Article 19, space debris mitigation. They're right on this. Space debris is a hot topic. The FCC had a meeting on, I believe it was the 23rd, and one of the issues on the agenda was orbital debris, and they kind of punted on it for a few months anyways, to give it more discussion, just because it's a very hot topic. But here the UAE has decided that space debris mitigation is going to be very important, and they're going to address it specifically and point directly at private operators in particular. Each operator authorized to own or develop a space object or carry out or participate in space activities shall take the necessary measures and plans to mitigate space debris and reduce efforts thereof as determined by a decision issued by the board of directors. And basically, it has reporting requirements and such that these operators are going to be liable for. And Article 20 is about liability. Liability is a huge issue. In other words, it's going to require operators to be liable for damage caused on the surface of the Earth or aircraft during flight or to other space objects. And that's kind of verbatim language from the Liability Convention as well, Article 2 and Article 3, defining different types of liability. And it actually defines damage in subsection 2 of Article 20. And the state shall not be liable for any compensation arising out of an operator's space activity towards any other parties contracted with exercise of that activity, or any persons participating in the activity or during their presence at the invitation of the operator or the launching state in the immediate vicinity of the area from which the launch or the re-entry is to be carried out. In other words, the UAE says it's not going to be responsible for any injuries to any persons that are injured during a launch or a re-entry of a space object. In other words, we're basically saying it's basically assumption of the risk. If they're going to be around there, if somebody's injured or killed during that, during a launch or re-entry, the state can't be held can't be held liable to them, and that's legislated in this. And this interesting another thing is we have also talks about third-party liability. In all cases, the operator shall be liable for any damage caused to a third party on the surface of the earth or in an aircraft while flying inside or outside the state's territory and caused by the state-owned object or operated by the operator or jointly owned or operated. So in other words, this is basically what we call joint and several liability. It's saying if you or I were just walking around and minding our own business and we're injured by a space object that re-enters the atmosphere and that's identified back to an operator, that operator is liable, and they have to compensate the aggrieved party. That's basically all that is saying. Liability for damages to another space object. Now this is interesting because they are actually addressing what happens when an object actually damages another space object in outer space. And when the operator's fault is proven, the operator shall be liable for any damages being caused elsewhere than the surface of the earth to any space object or to persons or property aboard the space object, provided that the damage was caused by the space object, which is fully or partially owned or operated by the operator. In other words, this is basically going into what we call fault liability. Now, in the liability convention, there are two standards. There's strict liability for damage caused by a space object that causes damage to an aircraft or to the surface of the earth, and there's fault liability for damage that causes damage to another space object while in outer space. So the question is, how do we define, the big question is how we define fault and how do we actually prove it? And I think it's very interesting in subsection 1 of Article 22, it says when the operator's fault is proven. The question is, how do you prove it? This is providing a baseline. It's basically taking language from the Liability Convention and enacting it in this law, this domestic law. But the key is, how are you going to prove fault? And that will be according to the UAE's rules, I believe, their jurisdiction, their rules. And it'll be interesting to see how they develop this in the coming, as things progress. And there are actually liability limitations as well in this law. In other words, you can't, you can't shoot for the moon, so to speak, in terms of damages. There are limits, and basically, there are mitigating factors which are listed here. Insurance and guarantees, which are basically requiring indemnification insurance for damage, specifically if there are terms like in Article 26 for international claims where the UAE government would be liable. This basically says to me that they're looking for indemnification for any international claims that are made against the state. That's a quick look at this law. Like I said, I'd like to spend a lot more time on it because I think it's very fascinating how they put this together. But like I said, it's a lot in here. I don't want to make a long video. I've got other things I got to do, and obviously here it's a nice day out and we want to go out and enjoy it. Like I said, there isn't a link to this right now. This was forwarded to me by a colleague, but I was assured, like I said, this is for public consumption. But very interesting. I've been waiting personally for a long time to see this, and I'm really intrigued by what they have to say. But again, like I said, a very busy week for space law and policy and other space-related matters, for national security matters, and I think it's just going to get more exciting even in the middle of this pandemic that we're in. And with that, I want you to stay safe and healthy, and we will talk to you next time.